Okay, thanks for joining us. We're still looking at the criminal trial process. We're hanging in there, and we're up to use of evidence, including witnesses. Now, for evidence to be admissible, it needs to be relevant and obtained legally by the Crown, that is the prosecution. And that can be by way of witness testimony, real evidence, including recordings, charts, photographs of people together, or documentary evidence, which could be evidence from the crime scene. Now, something else that's really important in a criminal trial is that the evidence presented to the court through witnesses. Now, witnesses are people who know something about the case and who give evidence in court about what they know. The prosecution witnesses include the police officers who investigated the case and arrested the alleged offender, and it can be quite a complex process. Now, the examination of witnesses are called by both the prosecution and the defense, and that these people can be subpoenaed by the police to appear in court at a later date. Now, because we are in the adversary system, witnesses will be examined and then cross-examined by both sides. Expert witnesses may be called, and these are people who are very highly qualified in a very specific area of expertise. This might be DNA testing, or this might be a psychologist to determine someone's mental health at the time of the crime, or a different doctor who can give evidence to the court on what type of injuries allow what kind of body movement. Forensics, lots of expertise out there. Now, whilst witnesses have given their written statements prior to the trial, it is also a requirement in a criminal trial that the evidence in chief be given orally. Now, evidence in chief refers to the witness giving his or her own evidence. This questioning is undertaken by the prosecution for prosecution witnesses and by the defense lawyer for defense witnesses. Generally, a witness can only answer the questions he or she is asked. A police officer who has made a statement about the matter soon after the event can read the statement to the jury rather than memorize it, if the statement has been signed and provided to the defense. So when witnesses are cross-examined, the main point of the questioning is to highlight any inconsistencies in their evidence or in their recounting of events as they saw them. So sometimes people will say they saw the accused, and then when the defense lawyers ask very, very specific, very, very detailed questions, all designed to cast doubt as to how accurate that particular witness's memory of the occasion really is. Because of the higher level standard of proof being beyond reasonable doubt, the defense lawyers are only trying to create that tiny little bit of doubt. Now, just quickly, after cross-examination, the prosecution and defense can re-examine their own witnesses after the other legal party has cross-examined. This will be in order to clarify any issues arising out of cross-examination, because as I just said, very, very specific, very detailed questions. So the legal team will want to re-clarify and just to reiterate a few points to the jury. We move on, there are special rules governing the evidence by child victims and sexual assault cases. Now, this sort of evidence can be given via CCTV to save the child a trauma of having to confront the alleged perpetrator in a courtroom. So it just takes that, it removes them geographically to provide that extra security. So rules of evidence are another important area for us to talk about. Now, there are, of course, rules about what questions a lawyer can and cannot ask and how they can and cannot be answered by a witness. So these rules have been developed in order to try and keep the process fair to both sides. The magistrate or judge presiding over the court hearing will determine which questions are permissible. So there are a few that we need to think about. There is hearsay, And that is, witnesses may only tell the court what they saw or heard directly, not what someone else told them. So they cannot say, "I heard them say." Another one is opinion. So a witness cannot give his or her opinion in a court about another person's words or actions unless the witness is an expert in that field, and we have an expert witness. So they cannot read into their body language, they can only give fact, what they did or did not do, what they did or did not say. Not allowed to look at the tone, not allowed to comment on the tone of their voice, or anything similar to that. We also have relevance. So relevance is evidence that only relates to the matter under scrutiny, and that witness can actually discuss or give evidence about. We also have character. So generally, evidence cannot be given about the bad character of the accused. So another important area is the right to silence. So an accused person does not have to say anything in court at all. Though corporations must submit documents, and even when such documents might incriminate them, judges and juries are not supposed to interpret somebody remaining silent as evidence of that person's guilt. We also have confessions. Whoops, there we go. So a confession cannot be used in court unless it is made voluntarily. Confessions made to police, but not electronically recorded, generally speaking, cannot be used as evidence in court. Confessions under duress, that means unnecessary pressure or undue pressure, cannot be used either. And then we have illegally obtained. Oh, I'm going to run out of space with this. No, just made it. So a judge can refuse to admit any evidence which has been illegally obtained by the prosecution or even the defence. The judge or magistrate must consider the community's interest as well as ensuring a fair trial for the accused when deciding whether to admit or whether to reject any evidence. Generally, the police must prove that the evidence they have gathered has been obtained legally if it is to be admitted in the courtroom. So this could be evidence such as phone tapping, so recording people's phones without their knowledge, consent, or without courtroom permission. It could be on the legality of how DNA or physical evidence was obtained. It could also be anything from how a premise was searched and how evidence was gathered and taken away from a particular a place of incidence or residence or something similar like that.